Changes to contract. Another input to contract administration. Activities under this input are change orders and claims. Let me talk about change orders. What is the percentage of change orders to your contract price? With exceptions to owner's initiative or project changes, change order value manifests how the construction contract was perfectly developed. Changes to contract preoccupy the project teams of both owner and constructor. Changes are inevitable in construction projects that will require revisions after the issuance of bidding and contract requirements. Specification, drawings, or after the contract. Let us be sure only after the contract change orders can be done. Changes that may alter the contract, such as by addition, deletion, modification to the works, those are change orders. Addition, deduction, on-contract compensation, those are claims. Changes to contract can be initiated by the owner, architects, engineers, or constructor. Change orders. One of the changes to contract. The absolute rule regarding change orders. Change extra work orders are issued only for addition or deletion of work necessary for the completion of the project. Change orders should be within the limits of the general scope of the project as bid and awarded. The types of documents related to changes to contract are addenda, pre-contract award, changes at the bidding stage that must be incorporated to the contract. Change order after the contract is signed. Other modifications such as architect's supplemental instructions, work directive change, construction change directive, field order. Variations or changes to contract are affirmed by owner, which are owner increase or decrease in work scope, actually a prerogative of the owner. Consultants or constructors' initiatives. These are proposals to the owner. Concealed conditions at site, those that were not discoverable during the site survey at bidding or mentioned in the bid documents. Errors and omissions exist in design bid build procurement method where the owner employed architects engineers for design engineering. All these are converted to COR, change order requisition. Works not covered by contracts commence when COR is duly approved or contract amendment is issued, or emergency situations by exception as occurring. All requests for changes are in writing. Emergency change or site instruction. Emergency situations such as danger to life and limb, potential damage to the facility, severe environmental hazards. Work is carried out and COR is documented on the following working day. To ensure the emergency changes are handled properly, monetary limit is set, except where extreme danger exists, and carried out with the approval of owner's site representative. Some other requirements before executing a change order. Documents at inception. Constructor prepares the notices, drawings, specifications, cost estimates of change order, including analysis of time consequences, and written approval to proceed from owner. These are the change categories. First, scope. Second, design. Third, schedule. Changes in the work required by the contract but within the physical limits and general scope of the work. As an example, changes in design require modifications in execution methodology, may increase cost and extend the contract completion date. Constructive change orders in a form written or oral or acts of omissions resulting from an act or conditions by the owner. The constructor takes as if a formal change order was directed. Ultimately, when this occurs, this is formalized in COR, change order requisition. As an example, in a reply to a technical query causes the constructor to do extra work, and this is due to wrong interpretation by the owner of performance requisites of a specification. The constructor in this situation informs the owner that a change order will be applied. Evaluation and approvals for changes. The value of CO, change order, is calculated per the contract commercial terms, such as those in the schedule of rates. The total amount of the COR shall not be a lump sum or include percent contingency, since this has to be itemized and the contingency are factored in the bid price. Deadline is mutually defined without affecting overall project schedule. In case of approvals, contract amendment is issued by the owner. Separate invoice is issued by constructor after completion for proper tracking. NCOR is formalized if a decrease in contract scope. COR lead sheet or the change order requisition form contains date of request, constructor's name and address, identification of the change, description of works to be rendered, the reason and justification of change, design, scope, schedule, expected total cost of COR and delivery dates, delivery requirements, terms, and cost. The headings of COR summary contains date submitted, COR, cumulated from project start, value per change order. If the change orders are amendments, these are marked as amendments. Expected for the current month, an estimate or best assumptions. Change orders that are pending, issued, and approved. The summary is maintained throughout the contract period. Change orders and contract amendments are separately listed with running numbers, and constructor submits a change order summary with monthly progress statement. This is provided for in the Site Procedures Manual. Claims and other changes to contract expressed in the contract and construed as additions or deductions on compensation of contract amount. Claims are based on set criteria, usually written in the contract and defined in the conditions of the contract, such as extension of time, liquidated damages, indemnities, loss, and damages and expenses to life, person, and properties. In reality, handling claims is a tedious process. Therefore, the process and criteria must be clearly written in the contract. The originators of claims are claims by constructor and claims by owner. Let me go through claims by constructor. Claims by constructor: errors and omissions, suspension of work and work stoppage, accelerating and expediting, access or availability of site, incentive bonus, unit price contracts, delay due to strike and acts of God, and interference and delay by other constructors. Let me start with errors and omission. Going into the claims by constructor: errors and omission. Unlimited mistake in owner-furnished contract drawings, specifications, and information. A contract clause requires constructor to report errors or omissions and immediately requesting for prompt instruction or clarification from owner. Continued work in affected portion may obligate constructor to correct at its own expense any defective work already completed. The constructor, in this case, is presumed to be reputable so as to spot errors and omissions. The value of corrections are determined, then proposed to the owner for approvals. Suspension of work and work stoppage. Notification by the owner to suspend all or a portion of the work operation entitles the constructor, as a result of unreasonable delays, the right to claim for a time extension and the actual cost incurred. Accelerating and expediting. The process of speeding up work that results to adjustment in resources in order to cope with the contract completion date. There are types of expediting and accelerating order. Directed acceleration, constructive acceleration. Let's see directed acceleration. In directed acceleration by the owner orders the acceleration of the completion of the remaining contract work or its portion within the original or adjusted contract completion date. Constructor may be entitled to pending time extensions due to change orders and other excusable delays. In constructive acceleration, an event where no instruction or acceleration order is given by the owner, but the constructor spent extra effort to the directed work increase without time increase. Another event is when owner grants extension of time for excusable delays. That is shorter than the extension claimed by constructor. Access or availability of site that impedes constructor's progress. Potential claim when constructor is denied free access to all or a portion of the site due to physical conditions or circumstances which prohibit in the proceeding with the work. Examples are lack of right-of-way, delay by the owner in the acquisition of the site, incomplete demolition by others. Incentive bonus. This occurs normally when the constructor completed the project ahead of the agreed completion date. This must be written as a special provision in the contract. Make sure this is written. The people who participated at the start of the project may not be the people at the completion of the project. Unit price contracts, if it is that type of contract, results when the works performed and or materials provided are proven to be in excess of the quantity and or quality of the specific items shown on the bidding documents or other information. Delays due to strike and acts of God and man. Constructor is entitled to a time extension due to circumstances beyond his control, such as strikes by constructor's employees, labor disputes within the constructor's organization, boycotts by workers of constructor, fire, floods, unusual weather in the area of the site when normal climate is expected during project time, war, interference and delay by others, conditions that the constructor may encounter as a result of insufficient progress by other constructors, those hired by the owner. The condition that may happen is congestion or confusion in work area resulting to inefficiencies, especially common with joint occupancy. Claims by owner. The following are the common items: fines or penalties, materials not of specifications, defective works and damages, property damages, delay claims, liquidated damages, constructor's failure to meet timelines. We start with fines or penalties. Fines or penalties: a specific sum paid by constructor to the owner due from non-compliance with applicable statutory requirements. The requirements are actually the responsibility of the constructor. At the instance, the owner settles the fines or penalties with the regulators and claim the corresponding amount from the constructor. Material not of specifications: a situation wherein constructor failed to comply with requirements on materials as defined in the contract specification. The overall rule: the owner responsible for defective specifications, even though constructor considers the plans and specifications to be complete at contract. Continuing with material not of specifications, some reasons for the discrepancies. 1. Contradictions in contract specifications that are vague in broad terms and in an unclear statement during a revision of a specification. Second, revisions in drawings is not followed with revisions related to specifications or vice versa. This result to miscoordination. Third, use of or approve equal or substitutes when alternatives are applied without owner's approvals. Many times, this happens when the specified items were missed out in the bids and more expensive. Defective works and damages. The owner may file a claim for disputes due from defective workmanship when the constructor does not meet quality standards set in contract drawings and specifications, such as defective works like outstanding items, never addressed by the constructor. Defects list. Remaining to be defects not corrected. Non-conformances unresolved. All of the defective works are monitored and tracked. Property damage. Claims by owner or third party that resulted from damages to existing or adjoining property caused by the constructor. A hold harmless clause precludes the owner from any legal actions taken by a third party. Delay claims.
Major causes of claims resulting from constructor's failure to deliver the project within the contract completion dates. Constructor's failure to meet timelines. Owner may file liquidated damages. Intermediate milestone dates are considered contract timelines. Continuing with delay claims, liquidated damages is a specific sum stipulated and agreed upon in the contract as the amount to be paid for a loss to a party who alleges and proves a breach of contract, specified in figures for each day the project extends beyond the contract completion date. The breach and the loss that party wants to recover should be basically connected. Some make this as an opportunity to correct bid mistakes. Delay claims by virtue of IRR of Republic Act 9184 relative to government procurement. Section 68 of this law liquidated damages of the new rules for infrastructures and goods. The provision, as highlighted, states liquidated damages computation as 1/10 of 1%, 0.1% of the unperformed portion of the works for every day of delay, cumulative up to 10% of contract amount. If this occurs, the contract is rescinded. Construction delays existent in projects for some valid reasons or causes by the actions of the owner or the constructor. The types of construction delays are excusable delays, inexcusable delays, and compensable delays. Excusable delays entitle a constructor to a time extension which arises due to owner-initiated changes, severe weather, and other force majeure concerns, design problems. Inexcusable delays caused by events which should have been reasonably expected or generally of the constructor's own making. Compensable delays entitle the constructor to both extension of time and additional compensation. Examples are late delivery of information, late delivery of owner-supplied materials, impeded site access, scope changes, out-of-sequence work by owner. The change in methodologies may require additional resources. The evaluation steps on claims. The contract should clearly define the ways to settle the claims arising in the project. Early warning. Preventive action and strategy minimizes or avoids potential claim. Reporting of claims. Written notices for incidents on or off the owner's property. Research and review by owner. Claims are collated by owner and constructor. Settlement of claims per the commercial terms. The claims can be additive or deductive to contract cost. Looks easy, these steps would appear, but when costs are involved, there will be tough negotiations between the parties to agree to claims proposal. Evaluation of delay claims. Use the CPM, Critical Path Method, to analyze scheduled delays and their impacts, and analyze the concurrent delays and their total impact on the schedule, and the impact of a delay on other indirectly affected activities using the snapshot techniques. That is before and after a major impact to the schedule. Still with evaluation of delay claims, example of impact to schedule. With the Gantt chart showing the machine installation project, we have the project critical path in red. With the project end date of October 16, Task 7 install machine has a duration of 1 day, but required 2 more days to complete for reasons that are of excusable delay. The end date is adjusted to October 18. In this case, constructor applies for extension of time on 10/16 and claim for additional cost of 2 days. Calculation methods for claims can be adopted. There are 3 available methods. First, total cost method. Second, modified total cost method. Third, differential cost method. Again, these methods should be clearly defined in the contract. In most cases, the contracting parties do not have this in mind when signing. Everybody is in a hurry to affix signatures on the contract. First, the total cost method. The claim cost is equal to total cost incurred minus estimated cost. The disadvantages of these methods are: turns fixed price contract to cost reimbursable type. Assume constructor's cost estimate is correct. Accept constructor's inefficiencies as valid cost items. Straightforward, but owner needs to put more efforts to analyze the claims.
Second, modified total cost method. There are more analyses needed in this method. The claim cost is equal to modified total cost incurred minus constructor's bid price. Bid price is validated against adjustments made for constructor's errors. Cost of excusable and inexcusable delays are removed. Excluded also are portions of the work unaffected by the actions of the owner. Comparing with other bids, the difference between the average of the next three bidders and the constructor's bid is within 3 to 5%.
Modified total cost method explained. Step 1. Claims cost. Verified with the bid prices. Then validated against adjustment for constructor's errors. Sometimes taking advantage of the chance to make cost corrections. If okay or none looks irregular, proceeding to step 2. Claims cost. Minus cost of excusable and inexcusable delays, minus cost of portion of work not affected by acts of owner, purely related constructor's works. This is equal to step 3, modified cost, which is also equal to or approximately the average cost of the next three bidders. That cost should be within 3 to 5% variance. Third, differential cost method. A method of selecting a work to be executed like that which has been affected, comparing the increased costs affected by the change or disruption. Cost of work claimed by constructor is compared to the cost of a similar work. If that is okay, the cost of change or disruption is added to the cost of similar work. Then, this cost of change or disruption is added to the cost of work claimed by constructor. That total cost then becomes the agreed total cost of claims.
Learning check of Module 3, Part 4, Contract Administration, Continuation. Changes to the contract are change orders and claims. A system of managing changes are provided for in the contract. In a properly prepared contract, specific guidelines are written to minimize misinterpretations.